Hello and welcome to the LLG Grapevine podcast. You're listening to Helen McGrath, Head of Public Affairs, and Dennis Hall, LLG Bulletin Editor.
Hi everyone.
Well, I'm just back from the first day of our governance conference in Birmingham, and it really was a fabulous success. We certainly packed the programme and enjoyed being in person once again. And of course, our coverage in the next bulletin will tell you more about what's happened, what you might have missed, and what you can do to view the sessions online. It might just also highlight the outcome of the LLG's Got Talent competition, including the showcased Levelling Up Fund song written by Mark Cook of Anthony Collins to the tune of All You Need Is Love, or in this case, Luff. But more of that next week. Dennis, what are you starting us off with this week?
Well, Helen, it's that Bill of Rights. It's back. And here's the background.
Liz Truss was Prime Minister for just 44 days. It was reported then that her government felt that Dominic Raab's Bill of Rights proposals were, in their words, a complete mess. Raab is now back in government. He's back as Lord Chancellor. And guess what? His Bill of Rights bill is back too. Does that mean the mess is back as well? Dominic Raab's Rights Bill will resume its parliamentary passage within just a few weeks, according to media reports over last weekend. Raab told ITV News that the measure, which was shelved by Liz Truss when she became Prime Minister in September, would now re-inject a healthy dose of common sense into the legal system and end the abuse of our laws. Raab introduced the measure under his first spell as Lord Chancellor in Boris Johnson's administration. The bill is currently awaiting a second reading in the House of Commons. The bill would explicitly give UK courts supremacy over rulings of the European Court of Human Rights, such as the interim ruling by a Strasbourg judge last June, which blocked flights carrying cross-channel migrants to Rwanda. The measure would also create a higher threshold for foreign national offenders seeking to challenge deportations based on the right to a private life, and introduce a new permission stage for human rights challenges. Raab said that the legislation will return to Parliament in the coming weeks. It is likely to face a rocky parliamentary ride, however. One critic of the measure, Raab's predecessor as Lord Chancellor, Robert Buckland, last week described the measure as worse than useless. Interviewed in The Spectator, Buckland said, "It threatens spawning a whole range of domestic rights which I think really sit poorly with the English common law tradition." Buckland also said, "It's a real problem for people like me who want to just keep the rights culture under control." Now, other commentators in the bulletin this week suggest that this bill is a distraction from the real issues with our constitution. Are we living in an age of government by proclamation? Has parliamentary scrutiny all but vanished from our system of government? Many fear that those checks and balances that we learnt about in constitutional law are being ignored completely.
Well, LLG certainly submitted a robust response to the previous proposals, and we will be scrutinising the return of the legislation very closely indeed. Now, on the 8th of November, Levelling Up Secretary Michael Gove announced an expansion to the government's intervention into Liverpool City Council to get the city's finances back on a stable footing and deliver value for money for the taxpayer. New powers for commissioners over governance, financial decision-making and recruitment have also been announced to improve the running of the council. The move comes after the report on the council's progress revealed serious shortcomings, particularly around financial management and senior leadership. It also criticised the slow progress made in driving improvement measures. Levelling Up Secretary Michael Gove said, "I am committed to helping Liverpool City Council come out of this intervention as a stronger organisation, and that is why I am taking further steps to put the council on a firmer footing." Now, at the governance conference, Guy Clifton from Grant Thornton spoke about lessons from public interest reports and interventions brought. And here he talked about institutional blindness and that interventions are becoming more frequent off the back of austerity, Brexit, COVID, and now the cost of living crisis. But he also talked about leadership and organisational culture and the positioning of the monitoring officer. It struck me, looking at the figures, that 20 years ago, there were very few interventions compared to what we're seeing now. And it also struck me that one of the things that has happened over the last 20 to 25 years is the downgrading of the monitoring officer's seat over that period, in some cases to third or fourth tier, and again with some reporting to the 151 officer. Mere coincidence? I don't think so. Dennis, you've an item on proposed changes to the solicitor's conduct rules. Tell us more.
Well, yes, indeed. There are new duties and some important exemptions. Here's the story.
Junior lawyers will be exempt from a new professional obligation to report on anyone mistreating colleagues in the workplace, following a rethink by the Solicitors Regulation Authority. However, proposed changes to conduct rules that will give the regulator more scope to clamp down on bullying, harassment, or discrimination have otherwise got the go-ahead. Managers and firms will be required to treat colleagues fairly and with respect, and firms will have to ensure that their employees meet this standard. But only managers will now be required to challenge aberrant behaviour. Draft rules published for consultation in February required all individuals to challenge unfair treatment, but many respondents were concerned that this would put an unreasonable burden on some people, particularly junior staff and people who are victims of unfair treatment. The SRA has also dropped the parallel challenge requirement for firms because the rules already require firms to ensure that managers and employees comply with the code. The changes are flagged in an SRA board paper approving rule changes on health and well-being in the profession. The SRA say that spelling out in our rules that treating colleagues fairly is a regulatory requirement will help to promote the importance of a healthy workplace culture in the profession. It will also reinforce our ability to take action against any case of unfair treatment that poses material regulatory risks. The new rules will also apply to behaviour away from the workplace, where that behaviour is in the context of a relationship between colleagues, rather than a purely personal relationship. And according to the SRA, this proposal attracted most opposition. Separately, the SRA board also approved rule changes relating to solicitors' health and fitness to practice. These include making it explicit that fitness to practice includes the ability to meet the obligations of a regulated professional, as well as to carry out work. There have been two recent cases where a disciplinary tribunal hearing has been stayed indefinitely for health reasons, and yet the solicitor has carried on working. The SRA will now seek Legal Services Board approval for all of these changes.
Now, the draft voter identification regulations 2022 have been published on the Legislation Gov website. The regulations implement the voter identification measures set out in the Elections Act 2022, and in particular, the regulations make provision as to the application process by which a voter can obtain an electoral identity document, referred to as a voter authority certificate, or an anonymous elector's document. The regulations also make changes to polling station conduct rules for certain elections and referendums, and to petition signing place rules for recall petitions under the Recall of MPs Act 2015 to implement the requirement to show photographic. These regulations are the second of four statutory instruments following the Elections Act 2022 Commencement No. 2 regulations, as well as a further set of commencement regulations and a set of rules to follow in due course that will implement the voter identification measures of the Elections Act 2022. We are told that guidance for electoral administrators and polling station staff on the measures set out in the regulations will be provided by the Electoral Commission ahead of the intended implementation date in January 2023. In that case, we can expect the guidance before the end of the year. This is going to create a lot of work for anyone involved in elections, and LLG are pulling together a one-day elections conference to help you navigate the changes. Moving on, local authority finances are in a dire situation, but there are reports that despite new and increasing demands for services, more cuts could be coming our way. Dennis, tell us more.
Helen, you would think that the financial crisis facing councils could not possibly get worse, but it could. and our members could be at the front and centre of decision-making on all of this. Let me explain.
I make no apology for returning again this week to the desperate problems concerned with local government finance and what is expected in the government's autumn statement this week. LGA Chairman Councillor James Jamieson spoke to Times Radio to discuss the funding crisis facing councils as a result of demand pressures and rising costs ahead of the autumn statement. Councillor Jamieson said that without adequate funding, councils will need to make more cuts to services, including those supporting the most vulnerable people in our society. He said, "This isn't just about shutting a library or a leisure centre. This is going to be much more significant if councils do not see their income increase in line with inflation. And that will mean councils having to turn away vulnerable people, and this is at a time when we're seeing more pressures on our services because of rising demand," he said. And it's reported that most of the estimated £55 billion shortfall in the public finances would be met by making deep cuts to services. Treasury sources suggest that Prime Minister Rishi Sunak plans to cut £33 billion by 2027 to 2028, while raising £21 billion from taxes. Early drafts of the autumn statement, to be delivered on the 17th of November, have already been presented to the Office for Budget Responsibility. Now, all of this matters to monitoring officers, governance specialists, and those who advise on policy and decision-making because of the plethora of public protest and legal challenges that might well follow as councils formulate their budget cuts and service reduction programmes. Take a look, for example, at the LGL post entitled "Parents Launch Judicial Review over Closure of 3 Early Years Centres." In that case, the council is facing claims that it has breached the Local Government Act 2000 by the way that it took its decisions, a failure to comply with statutory consultation and wellbeing requirements under the Childcare Act 2006, and breaches of the Equality Act 2010. And these sorts of claims are very common and are bound to escalate if the autumn statement is as predicted. Let us know what services are facing the biggest cuts in your council. Go to the forum page on the LLG website and share what's happening in your council. Now, last week I asked about the monitoring officer's role when decisions arise to cut services that the council is under a legal duty to provide. But this week I ask, what is the role of the overview and scrutiny function in these situations? Does scrutiny have any real role when certain decisions seem inevitable? Answers, please, once again, to our forum page on the LLG website.
Now, the issue of member allowances following the flat £1,900 wage increase has been the subject of discussion by lawyers and democratic services officers, where member increases are tied to the usual percentage increase. LRG are liaising with ADSO and will certainly raise the matter at our Day 2 Governance Conference online. In the meantime, we've started a forum thread on the website to gauge approach across the sector, which we would be very grateful if you could contribute to. And on that note, that's it for another edition of the podcast. You can read more on that, the items discussed today, and many more besides, by going to Bulletin number 41, available on the LLG website now. So it's goodbye from me.
And from me too.
Thank you for listening. Have a good